Promissory estoppel is an equitable doctrine which in some instances can stop a person going back on a promise which is not supported by consideration. Promissory estoppel was developed by an obiter statement in the High Court by Mr. Justice Denning, as he then was, in Central London Property Trust Limited versus High Trees Limited 1947. Mr. Justice Denning based the doctrine on the decision in Hughes versus Metropolitan Railway, 1876, which concerned a tenant's obligation to carry out repairs. The obligation to do so was suspended in equity during negotiations relating to the tenant's potential purchase of the freehold of the property. In the later case of Tool Metal Manufacturing versus Tungsten 1955, the House of Lords affirmed the existence of promissory estoppel in contract law. In Central London Property Trust v High Trees House, the defendant, High Trees, leased a block of flats from the claimant, Central London Property Trust, in 1937 at a ground rent of £2,500. The defendant had difficulty in getting tenants for the flats during the war. The claimant agreed to reduce the rent to £1,250 during the war years. When the war was over, the flats became fully occupied and the claimant sought to return to the originally agreed rent. Mr. Justice Denning held that the rent would be returned to the originally agreed price for the future only. Central London Property could not claim back the arrears accrued during the war years as they were prevented from doing so by promissory estoppel. The application of promissory estoppel was approved and followed in Tool Metal Manufacturing versus Tungsten. Tungsten had been infringing a patent right held by the claimant. An agreement was reached to waive the compensation payments during the war years. The House of Lords held that the claimant could not enforce the compensation payments during the war years but could enforce them on termination of the war. They were stopped from going back on their promise to waive the payments in equity. The requirements of promissory estoppel: 1. A pre-existing contract or legal obligation which is then modified. It can only be used as a shield, not a sword. 2. There must be a clear and unambiguous promise. 3. Change of position. 4. It must be inequitable to allow the promisor to go back on their promise. 1. A pre-existing contractual or legal obligation which is then modified. In Coombe v. Coombe, 1951, a husband promised to make maintenance payments to his estranged wife, but failed to do so. The wife brought an action to enforce the promise invoking promissory estoppel. Her action failed. There was no pre-existing agreement which was later modified by a promise. The wife sought to use promissory estoppel as a sword and not a shield. 2. A clear and unambiguous promise. There must be a clear and unambiguous promise. This may be implied through conduct. This was established in Woodhouse AC Israel Cocoa Limited versus Nigerian Product Marketing, where the conduct of accepting the goods without questioning the invoice was seen as a promise not to insist on the term relating to price in the contract. 3. Change of position. It was required that the promisee acted to their detriment in reliance of the promise. However, this was changed in Allen v. El Nasser, 1972, where it was stated that the promisee need only change their position. 4. It must be inequitable to allow the promisor to go back on their promise. As promissory estoppel is based in equity, the equitable maxim of he who comes to equity must do so with clean hands applies. It must be inequitable, unfair, for the promisor to go back on their promise. This was seen in D&C Builders v. Rees, 1966, where Mrs. Rees was unsuccessful in raising promissory estoppel. She had acted unfairly as she sought to take advantage of the builders' financial difficulties and pressuring them to accept less money than she owed. In summary, promissory estoppel is an equitable doctrine operating in contract law, which allows a promisee to enforce a promise unsupported by consideration. For promissory estoppel to succeed, there must be a pre-existing contractual agreement which is modified. There must be a clear and unambiguous promise. The promisee must change their position and it must be inequitable to allow the promisor to go back on their promise. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.